Okay. Hey, everybody. It's Tom Carpenter here. I hope people can hear me. I should probably open up the chat window so that I can see live comments as they're coming in. But I'm hoping that you're able to hear me. I'm not muted. So if somebody, I got a thumbs up there. So I'm assuming that I'm okay. Excellent. Hi, Jet Setter. Great. So thanks so much for tuning in. I'm glad that you were all able to take a little bit of time out of your day today to join us. If you don't know me, I'm Tom Carpenter. I do a lot of webinars, but a lot of times when I start getting questions about things and I start hearing about them consistently from people, I decide, maybe I should go do yet another webinar. So I'm going to just make a little presentation here, and just to answer the question that seems to come up more frequently. Oops, I think I need to do something here. Here we go. This is I had to replace my computer recently, so let's try this here. Okay. I'm going to try to share my screen. Oops. And why is it not allowing me to do that? There we go. Window. Perfect. Share. Okay. I apologize for the technical difficulties. Let me just see here. Bear with me here. I replaced my computer recently, and as a result, I think it's going to ask me to redo this. So stand by, please. Okay. Let's try this one more time. Window, share. I apologize for this. I'm using a new system. I will be right back. Okay, let's see if this works this time. Apologies for the tech malfunctions. When I replaced my computer, apparently it was not allowing me to do that. Okay, here we go. Apologies for that snafu there. Here's the thing that I hear a lot from people. I've been hearing a lot about people who purchase either purchase a template or purchase a document, or license a document for their terms and conditions document. Other people have told me that they kind of cobble it together themselves, and I always offer to have people reach out to me to review the document that they're using. I don't charge for those reviews. Obviously, you don't need to spend money to fix something that's not broken, but I do have a strong view that a custom document is much more preferable to protecting your business. So just a few professional responsibility disclosures to get out of the way here. This could be viewed as attorney advertising. This is intended to be for informational purposes only. So I'm not intending to provide specific legal advice. By participating in this webinar, we are not creating any kind of attorney-client relationship between you and my office. If I already represent you, Obviously, that's different. Prior outcomes don't guarantee future results. So just a couple things about me. I've been practicing law for about 30 years. I represent clients primarily in the arts, entertainment, media, and travel industries. I used to work for a couple of major entertainment industry labor organizations, AFTRA, Screen Actors Guild, Actors Equity Association, ran the legal departments at a couple of those organizations. I'm admitted to New York and Illinois state bars, but also several federal courts, including the US Supreme Court. I represent clients in pretty much every state on transactional matters. And it's well over 700 actually at this point. But in addition to my law practice, I also own, I'm one of the owners of a small travel business, Huckleberry Travel. So I do the same things that you do. So let's just start off with talking about what a terms and conditions document is. If you're relatively new to the industry, maybe you think you know what this is, but I found a few people kind of conflating that lately. A terms and conditions document is an agreement between you and your clients. It's the boilerplate for all of the trips that you book. It governs how you're going to work with your clients when you're booking a trip. You want to secure your client's affirmative agreement to those terms and conditions, because it's not a contract between you and the client if it's one-sided and nobody's agreeing to it. And what we're going to be talking about today, I have a strong view that having a custom document is much preferable to having a cookie cutter template or something that's set in stone that you buy or license from somebody else. And here's why it's important. Your terms and conditions protect you from a lot of the legal risk that's out there when you're selling travel. And if you're not familiar with some of those things that are risky for you when you're conducting your business, there are all sorts of scenarios where fraud is committed in the industry, scams abound. You're handling your client's payment information, their credit card information. Chargebacks, having a terms and conditions document is critical if you're going to win a chargeback. And we'll talk a little bit more about that. When clients are traveling, all of these things can go wrong. We just dealt with the pandemics and the quarantines, terror threats, civil unrest, natural disasters, which seem to be happening every day. If anybody on this webinar is in Oklahoma or any of the other states in that area, Arkansas, where you had tornadoes yesterday, my heart goes out to you because it just looked really serious. Supplier default and bankruptcies, those happened during the pandemic, but they also happened before the pandemic. There were airlines that went bankrupt well before the pandemic, and there have been some since. And then travel is also highly regulated, so we have legal compliance and disclosures that we're required to make. So why do you need a terms and conditions document? I mentioned this earlier. You simply can't win a chargeback dispute without having clients agree to terms and conditions. That's something that the credit card companies changed a little bit during the pandemic. I'll talk a little bit about that later. There are certain things that you have to disclose to your clients when you're booking travel that are required by government agencies. It can make it really, really overwrought and time-consuming and cumbersome to make all of those disclosures in the normal course of doing business with people. A terms and conditions document can be an easy way to deal with that. You need written proof that you've made advisories to your clients. If they say, well, my travel agent never told me about X, Y, and Z, you can tell them about that in your terms and conditions document. And there can be some actual legal protections in case you get sued or you need to sue a client. So if you've seen other presentations I've done, you might have seen a version of this slide before. These are the 5 main categories that I put into a terms and conditions document when I'm drafting them for my clients. So the first is legally required disclosures. I mentioned that travel is highly regulated. So this is an area where you can make those disclosures that you're legally required to make. The role of an agent versus the role of an advisor. That's also something that you can put into your terms and conditions document. If you don't really understand that, the travel agent part of being a travel agent is that you are an agent of the suppliers that you're booking travel for. So as a travel agent, you have a fiduciary obligation to the suppliers that you sell. You can't undercut their pricing. Unless you're Costco, you can't um, you can't um, misrepresent their products. So you owe an obligation to your suppliers as a travel agent. As a travel advisor, you are an advisor to your client. So you have a duty of care that you owe to your client as well. So you have two different obligations that go in two different directions. Being in that middle spot between the travel agent and the travel advisor, that is a complicated place to be. That can create all sorts of questions in your client's mind about whether they're buying the trip from you, whether they're paying you for the trip, are you handling client funds? All of that can get kind of messy. So you can clarify that role in your terms and conditions document. Advisories to clients, we talked about that. You can advise your clients on risks of travel, direct them to the government websites where they can find out whether there are advisories or alerts. You can also uh, advise them that they might need a COVID vaccine or a yellow fever vaccine. You can advise them that if they have a criminal record, you don't ask about that, but if they have a criminal conviction that would restrict their ability to travel, you can put that into your terms and conditions document. Cancellation and refund policies, not just yours, but the suppliers. You can have your clients agree to your cancellation and refund policies and also agree that they are agreeing to the supplier's cancellation and refund policies, whatever those are, when they decide to book travel with you. And that's really important, especially for purposes of chargeback. And then also limitations on liability and force majeure. So obviously, as the booking agent for your client's trips, you don't have control over a lot of things that suppliers do. If suppliers are causing damage, injury, or loss, or hypothetically speaking, you send your clients to a resort and there's seaweed on the beach and it ruins their destination wedding and it was their special day. Well, it's not your job to clean up the beach. You can put something in your terms and conditions document where your client is agreeing that they cannot and will not be able to hold you responsible for things like that that go wrong on their trip. Force majeure, we talked about extreme weather a little bit earlier. If your power goes out because of a storm and you can't make payments that you were supposed to make for your clients, your force majeure policy protects you from so-called acts of God. So war, terrorism, fires, floods, hurricanes, power outages, pandemics, quarantines. If you have a force majeure clause in your terms, that will protect you if you can't do something that is unforeseen, unpredictable, or outside of your control. Um, so, uh, so what's in your terms really makes a difference. Oops, sorry here. Let me go back. Are you holding yourself out as a specialist? Are you functioning as a hybrid travel agency / tour operator? Are you making the disclosures that you require as required or needed? All of these things might be reasons that if I'm drafting your terms and conditions as an attorney, I might put different terms in your document than I would put in somebody else's. So these are just three examples of why a cookie cutter document might not be sufficient for you. So for example, here we go. Are you a specialist? If you are holding yourself out as a specialist in one of these areas or maybe something else, you are telling the rest of the world that I know more about this than the average person, and I'm going to do a better job taking care of you when you do these trips. So destination weddings, culinary travel, wellness, hosting and escorting groups, if you do come with me trips, adventure travel, travel for people with special needs or disabilities. In all of these areas, I might put something different in your terms than I would put in somebody else's who only books these trips on occasion. So I'll just give you an example. So let's talk about culinary travel. I have a client who specializes in travel for people who who are vegan, who have vegan. So she does vegan and vegetarian tour. I think just vegan actually. She doesn't have a lot of control over the restaurants, the cruise ships, the hotels that she's booking on her trips. If one of those suppliers does not adhere to the dietary requirements of her travelers, that is a touch point of risk for her because she is holding herself out as a specialist in vegan tours, or travel for people who are need to travel gluten free if they have celiac disease. Those types of things. If that is the foundation of your business, your clients are going to expect that um, what to do to make sure that the suppliers on your trip um, are adhering to those requirements. And if they expect that of you because you've told them that you're a specialist in that area, then I'm going to want to put some language in your document that makes it clear that you can't control that because you don't have a lot of control over whether the kitchen screws up. But it could be other things, destination weddings. I mean, you can imagine all the things that you might want to think about for that. Wellness travel, especially if you're sending people to like a meta spa or a yoga retreat, you can't guarantee that they're going to receive health benefits. You can't guarantee that they're going to receive treatment by an appropriately licensed medical professional. I mean, there's just all sorts of things where if you're telling people that you're a specialist, you're going to want to take extra care to have something in your document that reflects that. Because if you're holding yourself out as having specialized knowledge about a particular topic, you're setting the bar for yourself a little bit higher. We talked earlier about the role between the travel advisor and the travel agent. As a travel advisor, you have a duty of care that you owe your clients. And if you're marketing yourself as a specialist or an expert, there may be specific things that we would want to disclose or disavow in your document. And so think about that. I gave you a list of some of those things. There are others. If you're not a specialist, the question that comes to me sometimes is, well, I might book the occasional culinary trip, or I might book the occasional trip for somebody who has special needs or disabilities. Shouldn't I just have all this language in there? And I have a strong view that that's not a good idea if you're not holding yourself out as a specialist. If you're only doing one of these types of trips occasionally or once in a blue moon, you don't want to include more than is necessary. So like if you're not specializing in skydiving trips, why would you want to invite people to look at your terms and say, oh yeah, but you got a language in your terms about skydiving trips. I happen to book one with you, and maybe it's the only one you've ever booked in 15 years. And you've got this language on adventure travel that makes it clear that you are not taking responsibility for all these other things, but there's this one little thing that you didn't mention in that language, and now you're on the hook for that. So less is not always more. More is not always more. You want to really have something that has been crafted for the specifics of your business and the types of trips you book, the types of clients you work with, and the types of specialties that you have. So I mentioned earlier that you don't want to turn yourself into a tour operator. I see a lot of documents that are, just kind of throw everything into the document and see if it sticks, where there are provisions that might be great for a tour operator, but I don't know why a travel agent would want to take those things on. So pricing and inclusions, if you're strictly acting as a booking agent, as a travel agency, if you're not a tour operator, you might not have control over the pricings and inclusions on a particular tour. And so putting language like that in your terms and conditions is probably not going to be helpful to you. Room configuration, if you're just the middle person, you're the booking agent, you don't have control over that. Processing payments, if you are talking about pricing and payment processing and what types of credit cards you take, that's something I've seen in some documents. If you're taking your client's credit card and making the payment directly with the supplier, that's a supplier issue. That's not an issue for you. Refunds, guaranteeing when people are going to get refunds. If you're the booking agent, you don't want to promise your clients a refund in your document or tell them the terms under which they're going to get a refund if you're not setting those terms. And also safety or quality of the services. So I see a lot of these provisions in some of the documents that are that can be sold or licensed out there. And I think if you're a hybrid tour operator, travel agent, and there are some of those out there, we might want to put some of these things in. But again, for most travel agencies who are staying in their lane and just booking travel, I don't think you're going to want a lot of this stuff in there. And then legal disclosures. The right disclosures for somebody else might not be the same for you. So So here's just a couple of examples. Seller of travel registrations. Do you have your seller of travel number, or are you hosted? Are you using your host agency's seller of travel number? You can put those disclosures in your terms and conditions to put you in compliance with the law. That's not something you're going to find in a cookie cutter template or a cookie cutter terms document, because those have not been drafted for you. They've been drafted for, I don't know, some random hypothetical person. But you can make those disclosures in your terms and conditions document. The state of California in particular has very specific requirements for the language that you have to use. They have a whole like memo page sheet about this. And again, it's going to be different depending on who you are and how you're set up. Your operations. Do you charge fees for cancellations or changes? I would put different language in your terms document about cancellation and change fees, depending on whether or not you charge them. You don't want to tell people you're charging them and then not charge them, but at the same time, you don't want to leave that out if you're not charging, if you are charging fees. There are some agencies out there that check their clients in for cruises or flights. And when you do that, you're agreeing to the terms and conditions of that the supplier imposes on check-in. So do you have, if you do that, and if you don't, I mean, I don't recommend that people do this, but there are people who do it. So if I know that you do that, I would put a provision in your terms document that says that the client is giving you authorization to agree to those terms and conditions of check-in on their behalf. If you don't do it, I would not put it in there. Again, I don't recommend doing it, but sometimes people do that. And if you do that, I think you're taking on additional risks. So I'd put a different provision in there. Haven't really seen that in some of the cookie cutter stuff that's out there. There are people out there that book people using their miles or their points for a fee. There are specific provisions that I would put in there based on if you do that. Regulatory requirements. The DOT has requirements that specifically apply to you if you sell air tickets. And if you're booking air through consumer sites, airlines don't really want you to do that. So there's some specific language that I would probably put in your terms if I know that you're booking through like delta.com or united.com or southwest.com. So these are all things that might vary from business to business based on how you're set up and how you operate. And then I'm coming toward the end of the presentation. I hesitated about putting this provision in, but if you're using somebody else's document and you don't have authorization to use that document, there is a risk that you could potentially get sued. So I don't copyright the documents that I draft for agencies. I think most of my clients understand that when they're paying me for a document that's been drafted custom for them, that why should somebody else not have to pay to get the benefit of having a document that's going to protect them? But also, what protects them might not protect the next business down the line. But there are other people out there that don't customize documents, that just sell templates or forms, and some of those forms are copyrighted. And so if you're using those forms without authorization, you could find yourself on the receiving end of a lawsuit. And in fact, there's a lawsuit that's just been filed against a very large host agency for using or distributing or disseminating a copyrighted document that a service was selling or licensing rather to businesses. And so it's not like the risk is low. This is actually happening right now to somebody. So if you're using a document that is not your own, just be aware that there's a risk there. Hiring a lawyer is different. If you hire a lawyer for a fee to draft a document for you, you own that document. Well, at least when you hire me, you own that document. It's yours to do with what you choose. When you hire me, I'm actually representing your business. So if there's a question about the interpretation of that document, I'm available to talk to you about it. But it's not the same as buying or licensing a form. You're establishing a relationship with an attorney who is representing your business and who is available to you to have a conversation about the implementation of the document and how you can use the document, where the document protects you, where if there's a change that needs to be made later on down the road, you've got somebody you can call to make it custom for you. So just the key takeaways from this presentation: having a terms document isn't is not really optional these days. I actually didn't talk about the credit card authorizations, but maybe I should do a whole webinar about that. But the credit card companies now require that you have a terms and conditions document, and that the clients agree to those terms and conditions documents at the time that they authorize the charge. And so if you don't have a terms and conditions document and they're not agreeing to it at the time that they authorize the charge, then you're going to have a really hard time winning a chargeback. Should have put those slides in. So that's why I say it's really not optional these days. Chargebacks are a huge problem. You really need them. Maybe we can talk about that in the Q&A if people are still hanging in there with me. Specialization might require that you have special terms. You don't want to take responsibility where you don't already have it, and what works for somebody else's business might not work for you. So that's where you can find me if you need me. More than happy to have a conversation with you. And I'm going to look at the comments. I see one from Heidi. The question is, how often do you have to update the document? Can it be once and done? So I try to draft the documents that I do in a way that they don't need to constantly be updated and changed. So, I mean, you want the document to be stable and consistent. I'm just going to go back to this. So I think you want your documents to be stable and consistent. You don't want to be constantly updating and changing your terms. That having been said, obviously, when COVID happened, that kind of upended the industry. And there are some things that I changed in my boilerplate language about COVID because of COVID. There are occasionally new regulations that might be passed. So it's it's not the kind of thing where where I think you need to constantly update it. When I draft terms and conditions documents for people, I include the updates as part of the flat rate package, and because really, if there's like new boilerplate language if there's a new regulation and there's boilerplate that comes across my radar, it's as simple as sending out a newsletter for me. I am potentially going to send one out pretty soon to people because there are a couple tweaks that I've made recently, but my view, it shouldn't break the bank to protect your business adequately. When I do a custom terms document for you, I include the updates there. And again, you're hiring a lawyer. You're not just subscribing to a service that's going to just send you the latest version of their template. If there's something going on in your business and you have a question about it, there's somebody you can call. So let's see here. Website compliance, privacy policies from Nancy. Yeah. So a lot of people want website privacy policies and website terms of use, which is a little bit different. So the booking terms that I was talking about, those are contractual agreements between you and your client that govern how you're going to be booking travel for them. A website terms of use document is a different document entirely. That governs the terms of service for people who come to your website. Maybe they're poking around to see what you're all about because they want to potentially hire you to plan a trip for them. But maybe they never actually pick up the phone. So the terms of use would be things like that if they get a virus or a worm from using your website, that you're not responsible for those damages. Website privacy policies, I'm sure everybody knows when you're surfing the web, those little pop-ups come up. This website uses cookies. That a lot of that is because of a relatively new California data privacy law that requires you to have a data privacy policy. The thing is that law only applies to businesses that are doing like $25 million in sales to California residents or collecting data from 100,000 California residents. So it's not really something that, I mean, I wish I wish my business was doing that kind of volume, but if you're not doing that kind of volume in California, it's something that I don't think is a bad idea, because there is a lot of scrutiny about how websites are using the data that they collect from people. When I draft them for people, it's maybe a half an hour of billable time, so usually under $200 to get something like that pulled together. I do it again, custom for your business. I do it on an hourly rate, but the website documents is really website documents are really something that I think a lot of people, you're not sitting on a whole lot of legal risk if you don't have one, unless your business is really, really huge. Question from Mary Ann about what a custom terms document would cost. I Since I'm going to put this on my website and my pricing might change over the years, I'm not going to give a specific dollar amount, but I can tell you that I try to keep it around the range of a good solid mid range booking. I do it on a flat rate. When I do it on a flat rate for people, I do it. It includes drafting a custom terms document, talking through how to implement that document, talking through the workflow piece of it. So credit card authorizations, fee structure, um, uh, insurance waivers, all of that is part of the mix. It's really designed to be kind of a flat rate package that covers you from start to finish when you're working with your clients. There are other people on this. I know there are people here who I've worked with before. I think they can tell you that my rates are not exorbitant. So I do the flat rate. I do terms and conditions on a flat rate for and I also do complimentary consultation. So if you'd like me to talk it through with you specifically, my rates do differ based on a couple of different factors. If you're a member of ASTA, I have discounted rates. If you're hosted by certain host agencies or members of a certain other organization, I do have some discounted rates for them. But I'm happy to talk to you. I do 15-minute complimentary consultations, and happy to chat with you. But I do have a strong view that the industry is better off the more of us who get all of our ducks in a row. So I try not to make it expensive. And do I review TCs? I do, yes. If you've got something that you're using already, I'm happy to, and you want to send that to me in advance of a complimentary consultation, I'm happy to take a look at it and tell you what I think you're doing. If it seems like there's something they're missing, if you're good to go, you're good to go. As I said earlier, I think you don't need to spend money to fix something if it's not broken. That having been said, most of the time when somebody sends me something that they have already been using, usually it's more economical to just start over from scratch on the flat rate, because the flat rate also includes updates and all sorts of other things. But if it's just one or two small things that you need, and it's cheaper to just make edits to what you've already got, I'll tell you that, because I joke that you can always find a lawyer to take your money, but I try to use my powers for good. So I'm not that kind of guy. I'm very transparent about my billing. Joanne, we had a lively discussion in our host agency about how agents' advisors are characterized. A major E&O insurance company. Oh, yeah. So I know exactly what you're talking about, Joanne. So yeah, so there's an E&O company out there that has taken the position that if you do a lot of FIT, like if FIT travel is more than 50% of your business, that that could make you a tour operator, including if you're hosted, and even if you're not taking direct payments, you're not holding client funds, you're not taking net rates and marking it up. I've heard that too. A lot of my clients have said that to me. I used to have my insurance with that company for my travel business, and I had the conversation with them, and I was not comfortable with how they were characterizing it. And the tour operator E&O is much, much more expensive. This is not really about terms and conditions, but I'm happy to talk about it anyway. Um, uh, I have a strong view that I'm not a tour operator. I try really, really hard to keep myself out of that lane. I don't take net rates. I'm a hosted agency. My host agency agreement restricts me from taking direct payments and net rates and marking them up. And I'm fine with that, because there's a load of legal risk you do it that way. And so I was a little bit surprised when I heard that they were taking the position that people like me could potentially be viewed as tour operators based solely on the factor that we do a lot of FIT trips. So I pushed back on that. Eventually, I think we sorted it out, but it was so disturbing to me that that's the position that they're taking that I asked the question of a different insurance company, got a much cleaner, easier answer from them, and so I switched my insurance. But yeah, Joanne, that's truly an issue. So I'm glad you raised it. I'm glad I had an opportunity to talk about it. And if anybody has questions about E&O, like I said, happy to do a complimentary consultation. I'm not seeing too many other questions, but I don't know if anybody out there is typing right now. I'm just going to show Joanne's. That was Joanne's comment. If you didn't see it in the Facebook chat. Is that clarified in your terms and conditions then? Basically, there's not really an intersection between, there's not really an intersection between your terms and conditions and your E&O policy. So your terms, the way I think of it is, you've got your terms and conditions here, and you've got your errors and omissions insurance here, and they're right up against each other. But they don't really intersect very often. So your terms and conditions are designed to protect you from liability, from a whole range of things that could happen that are outside of your control. Like what I was saying earlier about a supplier, like you book your clients on an excursion, the motor coach gets into an accident, your client gets horribly injured, comes back and files a big lawsuit. Your terms and conditions can protect you from that. Obviously, the driver's not your employee. You're not responsible for the maintenance on the bus. So we can put a provision in your terms and conditions that protects you from that. There are other things that fall under the heading of professional negligence. You book your client's trip for the wrong date. You book a supplier that has just gone bankrupt, and you took their money and they didn't get their money back. Those types of things are professional negligence, and that's where you would probably need to file an errors and omissions insurance policy. So the answer is you need both. You need both an E&O policy, and you need a terms and conditions document. And Mega, I'm not going to I'm not here to trash anyone's insurance policy or insurance company. But I would just, if you have concerns that you book a lot of FIT, call your insurer and describe to them exactly what you're doing, and ask them the question whether you've got the right kind of policy, and tell them, because you don't want to guess wrong. So trying to shoehorn yourself, if they tell you you're a tour operator and you want to stay with that insurance company, that you can shop around for prices, you can ask other people what they would say. But if they say no, don't argue with them. If they tell you you're a tour operator, that's the policy you need to have in place, because they're making the decision about whether you're covered or not. E&O discussion would be fantastic. Yeah, so I've actually been thinking about, I was going to do another one about credit card chargebacks. Maybe I can do some Friday afternoon webinars for folks. But Drew, if you want to reach out to me, you can reach out to me at my email address, and I'll put the screen back up. So that's where you can find me. Email is the best. I know we're doing this on Facebook. Please don't send me something in Facebook Messenger. I am trying not to be on Facebook any more frequently than I absolutely have to. But email is the best. Phone calls are not the best. Facebook Messenger is the worst. But an email to me, usually we can get you on my calendar pretty quickly, I think. So I'm just going to riff until we can see if we get a couple more questions. But yeah, if people are interested in having me do these webinars, again, I just need to stress, and it's scrolling across the bottom of the screen, I'm not intending to give legal advice to any of you, But I do, since I'm in the industry with you all, I do have, I do hear the questions that come in that seem to have, commonalities. And so if there's something that's on my radar, so, sometimes I've done these webinars, I'm happy to make it a regular series if people find it helpful, and we could do different topics, different weeks, and I can try to do them as frequently as I can. But again, might be viewed as attorney advertising. It's not intending to provide specific advice, but if you would like to set up a consultation with me, just shoot me an email, and I'm happy to do that. My schedule this summer, like the rest of the world, I go on vacation in the summer, and I'm doing some fam trips and going to a few conferences. So my schedule is a little bit tight this summer, but there's at least one other attorney, maybe two, if I can um, hire this really awesome kid who I want to have come work with me. So we can try to set up a call, but my schedule might be a little bit backed up, just as an FYI. Um, and thanks everyone for taking time out of your day to chat with me. I'm really glad that so many of you could be here, and the high quality of the questions. This will be recorded and on my if the technology cooperates, this will be on my YouTube channel, and if not, we'll just do it again some other time. But I hope everyone's doing well. Have a great rest of the weekend, and look forward to talking to you soon. Thanks. Bye.